Hello, everyone. Good afternoon. My name is Linda Westrick, and I'm with Partners Resource Network, the PACT Project, and we are the nonprofit agency that operates a Texas statewide network of training and information centers, or better known as PTIs. We are funded by the Department of Education Office of Special Education in Washington, D.C., so that means that we are completely free to parents of children with disabilities as well as youth with disabilities. And some of the things that we do is we help parents understand the disabilities that their child might have, find program and services, participate as team members with the IEP and IEP meetings with the school districts. We also help parents gain needed advocacy skills. So there's a lot of things that we do. At the end of this workshop or webinar, there will be a poll that comes up. If everyone could please take that. That is our evaluation, if you will. And it kind of helps us know where to make changes and what we might need to do to improve. So I will go ahead and turn everything over to Allison, and we'll go from there.
Thanks, Linda. Thank you for having us. Allison Scoburg here, Consolidated Planning Group. We are happy to be back with all of you today presenting another webinar. And today's topic is going to be the 5 legal documents that you need to know about and have. And we are happy to be partnering today with Christina Lesher. It's always my pleasure to do webinars with her. I always like to start with a little housekeeping. We are in webinar mode today, which means that we can't see you or hear you, but we do know you're there. We value your questions, and if you have a question, probably somebody else does too. So please put your questions in the chat box today. I'll be monitoring that, and we'll be reading those questions out and getting to just as many as we can. We're going from 12 to 1 today, so if you're planning your day, we will be finished by 1 o'clock. Today's webinar is being recorded, and you will get a copy of today's slides as well as a link to the recording following the meeting either later this afternoon or tomorrow. And this recording will also live live on our Consolidated Planning Group YouTube channel, which there are over 300 webinars out there for special needs families, a variety of topics that you can peruse for the step that you're on and kind of listen to them at your convenience. Consolidated Planning Group, we are a holistic special needs financial planning firm. We are in Sugar Land. We serve families all across the U.S., not just in Texas. We have over 30 years of experience, and we are an advisory and consulting firm. And really what that means is people come to us and they say, you know, I have a loved one with a disability that I need to plan for. You know, I'm going to retire and be retired for 25 to 35 years, but I have a loved one that may have 25 to 35 years of care needs once I'm gone. How do I plan for that financially? And it's not just financially, it's transition planning, it's housing. There's so many different things to consider. Once an individual with a disability has turned 18 or they're older than 18, there's a lot of things that change in landscape. We're nationally certified as Social Security advisors and members of the Special Needs Planning Academy. We help people put ABLE accounts in place, provide advice on how and when to apply for SSI and Medicaid and the other benefits that may be available. But one thing, you know, we spend time talking about this, and because it's so common and there's such confusion with this, Christina, I think it's important to clarify, you know, what we do versus, you know, what you do, because we get a lot of calls on a pretty regular basis of, I need guardianship, I need a special needs trust, I need to get my will in place. And so we're the money. We're the money. We're not the legal documents. We are not attorneys. We do not put trust in place for folks. So we do not, you know, petition the courts for guardianship or things like that. We work very closely with firms like Christina's, and she's the legal document. So she doesn't do the financial side of the house that we do, the money side, and we don't do the legal documents. So it's important for you to understand that as you're planning and you're going on this journey, that you need both of us, and we work very close together. Christina, you probably get a lot of calls on the financial side, like yes. We get calls for you.
Mm-hmm.
pretty common. So let me, without taking any further time, again, guys, as we're going through, this is going to be conversational today. Put your questions in the chat box. We're going to get to them. We're going to talk about the top 5 special needs documents. And Christina, again, certainly our pleasure to have you back with us. So I'm going to turn it over to you.
Thank you. Thank you so much. And I hope everybody out there is staying cool. And I just want to piggyback on what Allison just said. I don't do any type of financial investing. I don't do any kind of life insurance planning. How I describe it is I build these buckets for kids, and then Allison shows you how to fill them up and what's the best vehicle for that. So, all right, let's get started. So we're talking today about estate planning documents and what kind of estate planning documents you need. And this process can be incredibly overwhelming for parents and caregivers, and if you're a family member caring for someone with a special need or a disability. So I'm hoping what we're going to do today is just break it down into little bite-sized pieces. And remember, these are things that you need to have. It's not something that you have to have done overnight. And in fact, it's probably something that you shouldn't do overnight, so we can take some time and careful consideration on each document and what works best for you and your family. So what works best for a neighbor or a family member or a friend that you know, it may not be the best fit for you. So we're going to talk about estate planning documents that every parent or loved one needs to have, and that's going to be a will or revocable trust. We're going to talk about third-party trusts, first-party supplemental needs trust, and then documents for incapacity. And so one of the things I always tell my families is, you are thinking about guardianship for your child. Now you also need to think about what happens if you become incapacitated. And that sometimes is hard for parents to think, but we'll talk a few points about it today. And then Allison, we are going to talk about some beneficiary designations. If you take nothing away from my talk today, I want you to know that if you have a beneficiary designation, that is going to trump your will or other legal instrument that you have, because that is an agreement that you have with the financial institution, and it can really wreak havoc on your estate plans. So just to give you a quick example, if you have a life insurance policy and it names a minor child or a child with a disability as the beneficiary, even if you've got a trust set up for that individual, it's going to bypass that trust and go straight to the individual and cause all kinds of problems. But Alice and I both sleep, eat, and dream about beneficiary designations, and you're going to get a lot more information here in a few more slides. So we'll go on to the next one.
Well, Christina, one thing that I want to mention, I do mention this a lot, and sorry for anybody that thinks we're a broken record, but one thing that I want to say here is, as parents with kids with disabilities, our situation is specialized. You need to be working with specialists. So I always mention that, your legal documents, your planning, your money in the right buckets when we're planning for a loved one with a disability. This is not a DIY project. This is not your brother, the real estate attorney that says he'll do your special needs trust for you for free, or your neighbor that, dabbles in legal work. You really want to work with a specialist that's nuanced in the rules and the law as it relates to special needs. And then the reason behind all of this madness, if you will, is because we want to preserve our loved ones' ability to qualify for state and federally funded programs such as SSI and Medicaid and waivers and such like that. So I just want to encourage, there's a lot of places that we can and maybe should save money. We're all about saving money, the financial planner is all about saving some money. But when it comes to your legal documents, you need them, more importantly, you need them to be correct. You need them to be right, and we need to maintain your loved one's eligibility for state and federally funded programs. It's super, super important.
It is. And the reason why is because these trusts have to go through Medicaid and Social Security and be approved. I have a trust sitting on my desk right now that's really what I call a Frankenstein trust, meaning I could tell an attorney that I think these people went to church with, went on the internet, kind of combined a bunch of trusts together. And there's so many problems that we're just going to have to go to court to fix it, which is very time consuming and expensive. So, and we don't want to have a trust drafted incorrectly, because then your child or the person you're caring for may lose these very important Social Security and Medicaid benefits. So we're going to talk about wills. We're going to talk about trusts. Yeah, so there we go. So the question I get is, do I need a will or do I need a trust? And I'm going to give you the lawyerly answer, which is it depends. So a will, it becomes effective at your death, and a trust becomes effective during your lifetime. We've touched a little bit on probate assets and non-probate assets. The way I always explain a probate asset is something has to go through a will or go through court in order to retitle that asset when you die. So life insurance, retirement accounts, those will typically be non-probate assets if the beneficiary is on there. And like we talked about, the beneficiary needs to be updated and correct. And the will, as we've discussed, is going to be effective at death. In the will, you can appoint the people you want to be the guardians of your children, whether they're minors or with a disability. And it can have what we call a third-party supplemental needs trust. Now we're going to pause just real quick and I'm going to explain to you what that means. So a third-party supplemental needs trust is a trust established for a person with a disability, and the assets that go into this trust are assets that don't belong to that individual with a disability. It's money, it's a bank account, it's a house from mom, dad, grandma, grandpa, somebody else. A will can also contain a trust for a minor child. I have two minor children. I have a 13-year-old and a 16-year-old, and I've got trusts established for them in my will so that if I die and they're minors, then the money goes into trust for them, because in Texas, if you're a minor, you can't inherit property outright. You have to go to court and go through a certain legal procedure. So a revocable trust is something that is created during your lifetime. You can put certain types of assets in there. So we usually put bank accounts. You can have that third-party trust. And I like these revocable trusts if you have oil, gas, or mineral interests, if you've got property out of state. And the other reason why I like revocable trust is it's a way for you to create a document so that at your death, your child does not have to wait to go through the probate process in order to have a trust established for him or her. Now, you still need a will that would pour into the trust in case you forgot an asset and didn't put it into the trust before you die. So even if you have a revocable trust, you'll still need a will. And even if you have a revocable trust, there's still some maintenance to it. So a will is more simple and takes less work and is usually less expensive. A revocable trust is usually a little more expensive, takes more work, but there's some added benefits to it. And regardless if you do a will or a trust, and we're gonna sound like a broken record today, update those beneficiary designations. The number one asset that I see people forget about is the life insurance that is attached to your employer. My husband works at Centerpoint. He's got a life insurance policy. We never receive one piece of paper about that life insurance policy. I think maybe at our annual review for benefits, we might see it, but you are not going to get something in the mail. So if we have this life insurance through your office, through your work, and you die, and your minor child or your child with a disability is named on it, it's going to cause problems for you.
Christina, I would say that, a lot of the families that we work with, clearly they have documents, wills and special needs trusts and things like that. But quite honestly, wills and trust are one of those things that, and if you've done this, you're just very much not alone of that you're going to get to, and then it gets on that shelf and life gets busy and then we don't get to it.
Yeah.
We also commonly see where people have wills and trusts, but they haven't been reviewed in 15 years.
Yes.
Or they were done when the first child was born and they've since had 4 more kids and
yeah,
it hasn't been
Oops,
updated
yeah.
since. So could you give us a best practice
Sure.
of how often should you have your will and trust? Let's assume you already have one.
Mm-hmm.
If you don't, you need to get one. But if you already have one, how often should it be reviewed for law changes or just life changes?
So I would want a client to come in every 2 years to see me, not every year, but every 2 years, just to make sure there's been no change in the law. Medicaid and Social Security rules and requirements They will change every couple of years. So you're going to want to have a practitioner that specializes in special needs trust review your documents every 2 years. Now, for you personally, I think you need to review it every year. So meaning you need to review your documents once a year, make sure that you like the people that are named in the document, make sure you're still married to the person named in the document, and make sure you've collected all the beneficiary designations and it's coordinated. What I do is I pick a date during the year that is my like estate planning review date. I pick my wedding anniversary, June 3rd. So 1st of June, I get my estate planning documents out. I get my Excel spreadsheet out. Not that we have that many assets, but from time to time, we'll open or close a bank account or we'll make some minor changes. We just remembered my husband's retirement account when we were first married 20 years ago. We're like, oh my gosh, we remember we have an account with ERS we totally forgot about. So we went back through and updated. So I think once a year, pick an anniversary date, have an attorney review it every 2 years. And then after you review it and you have everything nice and neat, reward yourself. I like margaritas and queso. You need to do something nice for yourself to reward yourself. It's not fun. Carve out about an hour of time to do it, but it will allow you to sleep better at night.
And I just wanted to mention too, those beneficiary changes. One of the things that we see a lot is that if you're married, they make each other the spouse's beneficiary. If I die, my husband's going to get the money. And if I die and my husband's already dead and gone, then that's easy. The kids split it equally. And that is very common. And it is wrong for minor children. And it is always wrong for children with a disability that may qualify for other benefits like SSI and Medicaid. But guys, this is a real easy fix. You don't have to hire me or Christina to fix it. All you have to do is call the carrier. You can call your HR department for change of beneficiary forms for your life insurance through your employer, and call if you have outside life insurance. You can call the carrier and get the change of beneficiary forms. They don't even have to be notarized. You fill them out and send them back in, and they'll send you a confirmation in the mail that they have been changed. So I think that that's an easy thing. And one other thing I wanted to mention that we see common things like you were mentioning that old pension plan or old account from 20 years ago. Pension plans, old 401ks, 403bs, those are other areas where we see mistakes or on naming those other kids. So anyway, just to put that out there. So if you're taking notes, just make a note to just double check who your primary beneficiaries are and who those contingent beneficiaries are, and just make a note to get those updated. And if it's not clear, then just request the form and submit a new form and just get it taken care of.
And if there's not enough space to write in everything, then I will usually say, see attachment, and I'll add in a Word document that has everything that I want it to do, because sometimes the beneficiary designation form is like that big. So why do we need these supplemental needs trusts? If trusts are simply legal instruments, I want you to visualize it like a bucket. And any money that you put into this bucket is going to be protected from being counted as an asset for Medicaid purposes. As many of you on the call today know, there are many different types of Medicaid programs. I think the last time I counted, there's 109 Medicaid programs in the state of Texas, and they will limit the amount of assets someone can have. So when you apply for Medicaid, and this is also for Social Security benefits or SSI, they are going to look at the person who's applying for benefits, the assets that are in their name, and they're going to say some things are going to be countable. That's going to be a cash, a bank account, a second car, a second home. And then there's some things that are going to be exempt, which is worth $0. The maximum amount of countable assets that most Medicaid programs will have is $2,000. So if you place assets at your death or during your lifetime into a supplemental needs trust that's drafted correctly, that is not going to be a countable asset. And then the other thing that we'll do is it will protect maybe that child from themselves or from bad actors or from them being taken advantage of. We have clients that come in and say, we're not sure if we want to do Medicaid now, and they all have their different reasons, but we'll still talk about a supplemental needs trust because maybe that child with a disability, even though financially they may not need Medicaid or the parents don't want them to be on Medicaid, they still need to be able to have somebody be in charge of their money. And then within that supplemental needs trust, you can appoint a person to be in charge of the money. That's called the trustee. And then that way, if there is any kind of crisis with the trustee, they die, they become incapacitated, there are backups, and then you control where that money goes at their time of the death. What we don't want to do, and this is my pet peeve, is to have a person with a disability written out of a will and then their portion given to a sibling that they trust. Because even though that sibling, through no fault of their own, they may get divorced, they may die, and then that money goes up into their estate. Maybe they get married and the spouse spends all the money. But if you have a will that disinherits somebody with a disability, you don't have to do that. They can still inherit assets. We just have to do it the right way.
Christina, one thing that you talked about was, some people not wanting SSI, they have enough money, they don't necessarily need SSI, and don't want to follow, the Medicaid guidelines that come along with SSI. One thing I just want to mention, there's plenty of people that don't want the SSI, and I get that, but all of the waivers in the state of Texas are Medicaid waivers. So even if your child is not getting SSI and you are, for instance, interested in the HCS waiver, Texas Home Living, class, to name a few, you still are going to have to follow those Medicaid guidelines. And so that's really an important consideration. So I guess what I would say is if you got to follow the Medicaid guidelines anyway because of these Medicaid waivers, depending on the level of the need of the individual, like the HCS waiver for the highest level of need, the budget is like $340,000 a year. So I would argue even if a person is super affluent, that would be helpful in attendance services, respite services, and things like that. So if you're, going to try to maintain eligibility for a waiver, and you might as well get the SSI as well. And then the other thing that I wanted to make clear here with you, Christina, is all trusts are not created equally. So we have actually seen people where they say, oh yeah, I've got a little trust for little Danny, but it isn't a special needs trust. And so the special needs trusts are really the only ones in an ABLE account that wouldn't be counted against them for SSI and Medicaid purposes. Can you talk a little bit about that? I know that there's, we could have a whole webinar on all the different types of trust out there, but the key ingredient here is a special needs trust. Is that right?
Right. So we talked a little bit about trust for minor children. So I have a trust that's called a descendant's trust in my will. It's a special kind of trust. A descendant means a person born or adopted by you. So my kids, they have a trust, but they can be their own trustee when they turn 25. I might increase that age for my youngest at some point. But the supplemental needs trust are written very specifically so that that individual can never have access or control over the trust, which is a key element of exempting that trust for Medicaid and Social Security purposes. Allison, did I answer your question?
You did. And to Christina's point, Christina's children, she has a nephew that she's very, very close with that has special needs, but Christina's children do not have special needs. So that is why the trust that she has created for them are not specifically a special needs trust. So someone says, once a child qualifies for a waiver, they must take Medicaid. What if the adult child is still on the parent's insurance? I can talk from a perspective of a parent with kids with disabilities. I have one kid that gets Medicaid, Medicare, and is on our private insurance. From my perspective, I am a believer of keeping our kids with disabilities on our private health insurance if you can. Most group health plans, if you have a child with a disability whose disability started prior to age 26, you can keep them on your health plan. They don't advertise that. You got to call HR and you ask about it. They have a special form. And quite honestly, nobody ever calls and asks them about it. So you might be transferred like 15 times before you get somebody that can help you. But you definitely can keep your disabled children on your private health insurance past age 26. But Medicaid, while it does cover a lot of things and there's a lot of services and things that Medicaid covers, a lot of the families that we serve, and I'm the same, we see a lot of specialists, and I'm not willing to change those specialists. We see who we see for a reason because we have complicated, difficult customers. Anyway, we're complicated, and we need to see those specialists, and I'm unwilling to waiver. Yes, I'm
yes.
unwilling to waver from that. So I am, again, I still keep that private health insurance, even though we have Medicaid and Medicare. And just so you guys know, Medicaid is always the last payer. So if you have private health insurance pays first, Medicaid pays second. And when they become eligible for Medicare, it depends if the employer has over 100 employees or not. If they do, Medicare pays first. Then your primary insurance is second, and then Medicaid third, and then Medicare and primary insurance could be flip-flopped depending on the number of employees at the employer. So I think it's really, really important, especially for our kids that have critical care needs. But that was a really, really great question.
And there's one other benefit to this, is the Texas HIP program, which is the health insurance premium reimbursement program. I'm going to put it in the chat box. So my nephew's on a waiver program. He's a minor, but this is still going to apply when he turns over 18. Is that my sister has a private health insurance. She sends her payroll, her paycheck every month, and then Medicaid reimburses them for the premium. And then she takes that premium reimbursement and pays for a life insurance policy. So it's a way to stretch that family budget. So not only can you have Medicaid and you have less out of pocket, you may have that whole premium reimbursed for you. And then you go back to Allison and Allison tells you how to invest it. It's a beautiful thing. And I put some information in the chat box.
So yes, definitely check out the HIP program. And a few years ago, we had some families that were using the HIP program and they felt frustrated, like they were beating their head against the wall with it, trying to get reimbursement. But I think it's vastly improved over the last couple of years. And I have heard like really wonderful things and about the ease of getting the HIP program in place. So if you were disenchanted before, go back to the well and try again on that.
Yeah, and just one other little tip is make sure that when you send it in, if you've used Medicaid a lot, send in those EOBs that you have from the insurance company that is handling your Medicaid for your child, and that will help speed that process along.
Someone said that our chat box is disabled. Make sure you put your comment to everybody. I'm not seeing it. It didn't come through. I'm not sure what's going on with that. But if the chat box is disabled, if we're having a little technical difficulty, then put your questions in the Q&A instead. So sorry about that. I'm not sure what happened with that. Okay, so we're back on the third-party special needs trust.
Yes. Okay, so the third-party special needs trust or supplemental needs trust, by the way, special and supplemental, those terms used interchangeably in Texas. As we talked about, it can be in a will, or it can be in a revocable trust. And the funds come from a parent, family member, anybody than the beneficiary. And the benefit to doing this correctly, besides you're going to maintain Medicaid eligibility, is that there's no repayment back to the Texas Medicaid system when your child passes away. One of the big misconceptions I have in my office is, oh, I don't want to set up a supplemental needs trust, Ms. Lesher, because I heard that when my kid dies, it all goes back to the state of Texas. That is not true for these third-party supplemental needs trusts. You can name alternate beneficiaries, and these types of trusts are reviewed with a lot less scrutiny than what we call first-party trusts, or trusts that are using that beneficiary, that child's money. So we want to use a third-party trust. We use a first-party trust, as we're going to talk about, in what I call a oops situation. It's an oops, something has happened. Oh, Allison, yeah, you're muted. Sorry.
I do that at least once a day. Linda, if you can hear us, the chat box is enabled. If you can, make that to where people can put comments in the chat box. We're having a little technical difficulty with that, and I can't fix it on my end. So, okay.
So there was a good question really quick about, is a special needs trust revocable or irrevocable? They need to be, I typically do third-party supplemental or special needs trust irrevocable. I know some practitioners will make it revocable, and they have their reasons. The reasons why are a little outside the context of our talk today, but these first-party trusts have to be irrevocable. So these first-party trusts, what are they used for? I call them the oops trust. Something has happened, or you have a kiddo that's working and is making too much money to fund an ABLE account. By the way, Allison has the best webinar on ABLE accounts that is available to you, and it's on her YouTube channel. So a first-party trust, an example would be a grandparent dies, they've named the grandchild as a beneficiary on an account, and now all of a sudden you've got $20,000, which is nice, but it's going to be too much money in that child's name and will disqualify them potentially for Medicaid benefits. So we've got to do something with it. So we know we can put that money in an ABLE account up to $17,000, but we've got a little bit extra money. Maybe we could spend it down on a pre-need funeral contract or other things, but maybe the family doesn't really want to spend the money. So maybe a first party trust would be a good fit for that particular situation. Sometimes we will use these in child support cases if the child support is causing them to be income issues. But these first party trusts are reviewed very carefully by Social Security. So the person that's the grantor or the person establishing the trust has to be the parent, grandparent, guardian, court order, or by the beneficiary themselves if they have the capacity to do so, or if they have a financial power of attorney, then the financial power of attorney can sign on their behalf to establish the trust. The money that is used for the trust has to be for that child's sole benefit, meaning no money can be spent on any other person. Then at the death of the beneficiary, the money has to go back to the state or states that that child received Medicaid benefits in the same proportion that they receive benefits from the state. So if they had Medicaid in Texas and Oklahoma, and Texas gave them more money than or more Medicaid benefits, then Texas would take a larger share of the repayment. And then the money has to be placed before their 65th birthday. It can be spent after their 65th birthday, but if any money goes in after their 65th birthday, it's considered a gift or transfer of assets. Anything after the state gets paid, you can name backup beneficiaries, but the state of Texas or that whatever state they live in has to be named as the first beneficiary.
So we got lots of good questions. One said, can life insurance proceeds be used to fund a third-party special needs trust? The answer is yes. And I'm a huge fan of that because that leaves your assets nimble for your 25 to 35 years in retirement. We have people that have plenty of assets. They're not worried of running out of money and they have enough money to fund the special needs trust. But even for them, we suggest having life insurance as an umbrella over their financial plan of just in case we have 15 years of declines in the market, just in case there was something that was unexpected that, wasn't planned. So, but definitely life insurance proceeds can be used to fund a third-party special needs trust. I've actually, had people come to me and say, well, such and such, advisor said I need the $3 million, life insurance plan. I thought they were just trying to sell me something. And the reality of it is the life insurance is one of the best bets. If you are still young enough and still insurable, don't wait until you're too old and you have had major health problems and you can't get it anymore, because it is a great idea, and we help people with that all the time. We had one person that said, if you have a trust outside of the U.S., which is a disabled U.S.-born child, is a beneficiary, which is the beneficiary, can they still qualify for Medicaid and SSI, or would this be an asset, be it that the trust was outside of the U.S.?
Unfortunately, I'd have to take a look at the trust document. I can't answer that. It would depend on the terms of the trust. What we don't want to have in the trust are things like what we call crummy or Cristofani powers, where that child can take money out of the trust or has a right to money. So we look at the document and see if that child has any right to the trust assets or has any control over who is in charge of the money. Even maybe that language doesn't become effective until they become older. But the best bet is to have that trust reviewed by an attorney.
Okay, great. And our chat box is now enabled. People can put stuff in the chat box. One other question I want to ask before we move on, because we've been talking about third party and first party. So there's always confusion on that of which one do I need. So the third party, again, is the one where if we're going to leave life insurance proceeds to the person and there's not going to be a Medicaid payback, somebody else is giving them money, it's an inheritance or things like that, that's the right way. And the first party
Correct.
is their money. It could be a
Yes.
scholarship refund. It could be their income. It could be somebody accidentally left them money and didn't leave it to the third party special needs trust. It could be a settlement, or a wrongful something at birth or something like that, where there was some type of settlement and things like that. But one question that comes up all the time, Christina, is how many trusts can we have for one kid? Because you can only have one ABLE account per individual with
Yes.
a disability, but
Right.
sometimes there's divorce situations and our grandparent situations, and they don't want such and such being in charge of the money. So how many special needs trusts can an individual with a disability be party to?
Well, there's no statutory or policy limitations for these third-party trusts or first-party trusts. The complication gets in where who's going to pay for what out of each of the trusts, because all the trustees have a financial or fiduciary responsibility for making distributions. Hopefully, especially with divorced parents, there's some kind of coordination. The short answer is there's no limitation. The bigger answer is what are the family dynamics and who's going to pay for what and when.
That's right. So someone says, can we get a life insurance policy under a disabled child's name as long as we, the parents, are the owners or the beneficiary? And so the answer is it depends. It depends on the child with a disability and what their diagnoses are, and if in fact they are insurable. So that's the first thing.
That's the
And we shop that all over the place. But one key thing, so yes, you can, provided that the individual is insurable, but it is important that the owner is the parent, not
Yes.
the child.
That is
Okay, because
correct.
if this is
Yes.
a permanent life insurance policy, guess what? Permanent life insurance policies have cash value, and that cash value will be counted against them for the $2,000 for Medicaid. So if you have this, maybe you bought a policy on your kid years ago and they're about to turn 18, you're going to want to call that insurance company and say, I need a change of ownership form. I need to make sure that the ownership of this policy remains with me, even though they turn 18, because some carriers just automatically, it becomes the individual's asset once they turn 18. Other companies have a form, but as long as you're the owner, that cash value will not be counted against them. So that was really, really a great question.
And Allison, the other little detail to that is if you change ownership, that's a transfer of assets for Medicaid, and Medicaid's going to want to know about that. So let's say the cash value of the policy is like $500. You're going to have to figure out a way to show Medicaid that it either wasn't for the purposes of qualifying for Medicaid, or you have to give your kid $500 in order so there's no penalty or loss of eligibility. So that means that you can't, if your child has assets that are over $2,000, you can't just willy-nilly give them away, because Medicaid's they will find out and Social Security will find out. You have to explain. So,
yes, and that's true. But if they're a minor and it stays the owner of the parent, then it'll be, in that example, it will be okay. And furthermore, if you say that the cash value within that policy will be used for their final expenses, that is an acceptable.
They can have, they can have it up to $1,500 and burial funds. You just, the best policy is just not to purchase something in the name of your disabled child. Purchase it, make the parent.
Someone says, I've heard that special needs trusts have restrictions on what they can be used for, but ABLE accounts do not. Can the funds from special needs trusts be used to pay for housing and related expenses?
So on the first part, so it depends on the trust document. Years ago, we used to say in the trust, you can't pay for food, clothing, or shelter. I think that's what they're talking about. In 2006, they got rid of clothing. It can pay for food and it can pay for shelter. You just have to know that if you take money, and this is true for a first-party trust or a third-party trust, that if you pay for food and shelter, you will have a reduction in the SSI benefit. If your child is on your Social Security retirement record and not on SSI, it's different. So the short answer is the trust can be written so that it's flexible, so that it either can maintain maximum Social Security and Medicaid benefits it could reduce it, or it eliminate it, depending on what the trustee thinks is in the best interest of that child. So the short answer is, yeah, no, you can make, it can be more, it can be flexible like the ABLE account is.
And one key thing, because I think, Christina, a lot of people say, you know, why do I need an ABLE account and a special needs trust? It seems duplicative. And I think one of the key things is, well, A, you can pay for food and shelter out of the ABLE account without a 1/3 reduction to SSI, as you just said. But what we need to remember is that you can never have more than $100,000 in an ABLE account before you disqualify for Medicaid and SSI, whereas a special needs trust, you can have an unlimited amount of money in a special needs trust. And furthermore, we beat a dead horse to death on the beneficiaries. You can leave a beneficiary a special needs trust. You cannot leave an ABLE account as a beneficiary. So when we have a loved one with a disability, their care needs, once we're gone, are going to be far more than $100,000 in what an ABLE account can cover. So that's why it's kind of important to have both.
Yeah. And the other thing about the ABLE account is that there is a required payback like the first party trust. I like to think of like ABLE accounts like have a very specific purpose. Like the kid's working, there's a little oops accident, but I don't really see it as a long-term planning vehicle. I think a third party trust works much better. Okay. So now
I just wanted to say I call it a save to spend account because you don't ever want to give that money back to Medicaid. So a save to spend, but it's tax free and tax free distributions. And so if you look at it that, you know, you're always going to be able to spend that amount out of the ABLE account and not let that be used against you. Use it as a save to spend.
Absolutely. I like the way you explained that. Okay, so now we're talking about not death. Now we're talking about becoming incapacitated. So even if you're married, and even if you've been married a long time, you still need a financial power of attorney. I like to make the financial power of attorneys effective, meaning your agent, your spouse, the person you trust can use it as soon as you sign it. Easier to use, but easier to abuse. But if you have any concerns about the person listed on that financial power of attorney, they don't need to be on there. Once you have a financial power of attorney, I would suggest sending them to the financial institutions for their pre-approval, especially for retirement accounts, so that your spouse, if he or she becomes incapacitated, you have the ability to immediately contact them and make distributions or make management or investment decisions. Then I think our next one is Allison, I think we slipped back on the slide. Yeah, go back one. Perfect. The medical power of attorney, which becomes effective only when you cannot make a medical decision. A HIPAA release, which could be effective as soon as you sign it. And it's a document that has a list of people that can access your medical information. A directive to physicians, sometimes people call this a living will, and it talks about what kind of care you would like at end of life. Or a DNR. A DNR is a document that says you do not want CPR. Typically, we see these in hospitals or out of a hospital if someone has been ill. And then an appointment of a guardian. You could do this as an appointment of a guardian for your child and or yourself. So let's say you're divorced and you want to make sure that your ex-spouse or an ex-sister-in-law or a family member that's estranged from you never can go to court to make medical or financial decisions for you. You're going to want to think about that document. And then I have minor children. So I have an appointment for healthcare for minor children so that if my husband and I, if we're out of town, then my family can make an emergency medical decision for my boys. And then maybe if this is something that you're interested in is an appointment of designation of remains. That's just a document that says who's going to take care of your funeral and what your arrangements are, and then maybe a medical study for a body or organ donation. So these are all these little documents outside of a trust or a will that you need to think about, maybe for you and maybe for your child if that child has the capacity to sign powers of attorney. So Allison, I'm going to ask that you join me so you and I can talk about the next slide where we have our guardianship discussion.
I just want to mention too, before we go on,
Mhm.
that I'm a huge fan. So we're talking to you, we're talking about these documents, power of attorney, HIPAA release, medical power of attorney, financial. And it's important for you, but it is also important for your aging parents. Have
Yes.
intentional conversations
Yes.
with your aging
Yes.
parents. And I am a huge, huge fan of these documents for your neurotypical kids that you're sending off to college.
Yeah, or any kid you're
So
sending off to college. Once they
yes,
turn 18, yes. Yeah.
So don't forget, don't think just you, kind of think the bigger picture, and just know that if these documents have been on that back burner, on that shelf of the things you're going to get to, guess what? Your parents or other aging family members, same deal. And so just have intentional conversations with them on this for sure.
So Allison and I have really good conversations, I think, during our webinars about guardianship. So a couple of things about guardianship I want all the parents to know. You can do it anytime after the 18th birthday. A lot of times we see the kids, they're turning 18, they're in school. The schools may say, listen, we want you to go get guardianship. And I want all the families to know what the guardianship does. Once you're in a guardianship, it's very difficult to remove. It's called restoration. We also have to prove to the court that there is no other least restrictive alternative or support services that we could provide to that individual that would make the guardianship not necessary. Meaning the courts are very concerned and instructed by statute, by the law, to make sure that they're not putting people under a legal process and taking away their rights if there's some other alternative. Sometimes the alternative may be a power of attorney that we just talked about. Maybe if they're in school, there's something that's called an educational power of attorney, where that child could appoint mom or dad to sit in with them during an R meeting and review an IEP. Or maybe they want to sign something that's called a supported decision making, which will allow that individual to appoint somebody to help them make a decision, figure out what is the consequence of making that decision, and give them permission to talk to third parties when making that decision. And you could get more information about that from Navigate Life Texas. But courts are very sensitive and very concerned about people getting guardianship when there may be another process, because guardianship is a process. It is a lawsuit, meaning you file a petition with the court. It's a lawsuit. People have to be served, meaning a constable is going to come out to your house and serve your child. That child, once they turn 18, will also have to have something that's called an attorney ad litem, which is an attorney appointed to them to represent their legal rights. There's also a doctor's letter required that will show in detail the nature, depth, and how the diagnosis for that child's incapacity. So once you are appointed the guardian, then you still have to do an annual review, which means you have to report to the court on an annual basis how your child is doing. So there's really two parts to the guardianship. There's a guardianship of the person, and what we call a full guardianship, which is a guardian of the person and estate. We see people with just a guardianship of the person, where maybe the child's receiving Social Security and that's the only money that's coming in their name. Or maybe that person has money in their name and the court feels that there needs to be somebody to manage assets that are outside of Social Security, because Social Security is outside of their jurisdiction or control of the court. So this guardianship decision is on a very case-by-case basis. And what I tell the families is, we are not going to run right out when that child turns 18 and get guardianship until we've had a thoughtful discussion on the pros and cons. Years ago, I had a family. They came in, they had their daughter put under a guardianship to get her out of an apartment lease to show that she was incapacitated, because she had moved in with some friends, signed a lease that she really shouldn't have signed. She didn't really understand what she was signing. Once that was resolved, then the parents didn't want to have to be responsible to the court anymore. And I had to explain to them, sorry, there's not a medical reason for us to remove the guardianship. She cannot be restored. You're going to have to keep her in the guardianship.
So I think, the key thing, I think you really did a great job of explaining the alternatives to guardianship and kind of the law of the least restrictive, most appropriate. And I think that that's really important. We always tell families that you don't have to know when you go to meet with somebody like Christina to discuss guardianship. You don't have to know what you need and want. Christina is trained to walk through that with you and have those intentional conversations, discuss your options, learn a lot more about your loved one, and make intentional, recommendations that way. So you don't have to know everything. And the other thing is, if you start out with something less restrictive, like a power of attorney supported decision-making agreement, and you try that for a couple of years and it's clearly not working, wheels off the bus, you can always upgrade to something more restrictive if proven that this isn't working. Now, one question I do have for you, and I get this quite a bit, is kind of that slippery slope. We've actually seen the other side of things too, where our kids will sign whatever we put in front of them, right? Okay, so there is a such thing as an individual signing something that clearly doesn't have the capacity to understand what they're signing, and that can become an issue, like we've seen in hospital situations where they didn't accept the document because they said that the person didn't have the capacity to understand what they had signed. But my other question is in an example, because we've definitely seen people that have a loved one with an intellectual disability. Their IQ is below 70, but they're very functional in many other areas, arenas, what have you. If in that example, we have someone that has the capacity to sign a power of attorney, healthcare power of attorney, supported decision-making agreement, and we have this in place and the parent dies, those documents kind of go away. That's kind of over. What happens to the individual with a disability that has an intellectual disability at that point, where maybe they don't have the wherewithal to handle financial transactions and other things, like they need a lot of help with stuff? What happens in that example?
Well, hopefully we can prevent that situation from happening by appointing backups on the supported decision-making and the financial power of attorney. What would happen after that is they may have to either sign new documents, or they may have to go through a guardianship process if they're not able to understand it. And again, it's going to be on a very specialized case-by-case basis. It's not going to be, your resolution's not going to be the same as your neighbor's. One of the questions I saw in the chat box is, if you become your child's guardian and you want to move out of state, what limitations can the court or the guardianship system place on you? So once you're under the umbrella of a court system, you have to get court permission to move from county to county or from state to state. Within Texas, it's a simpler process, but going from state to state is incredibly complicated. You have to have two sets of lawyers, unfortunately. Okay.
Yes, that's important. You just hit that too, because even honestly, if you were in Harris County, for instance, and you moved to Fort Bend County, that guardianship has to move as well. And someone said, I have a savings account for my son. I will be having him apply for SSI in a couple of weeks when he turns 18. What is the best option for me to move that money so he can qualify for SSI? The best option is to go to a ABLE account. You can put up to $17,000 a year into an ABLE account for 2023. If the individual with the disability is working, you can have an additional $13,590. We can help you with that and also provide some guidance on, what and how. But you need to make sure it's a legitimate move. And not legitimate is moving the money from his account to your account. You could spend down the money. You could spend down the money for his benefit and have proof that you spent the money for his benefit. You can legitimately move it from his savings account to the ABLE account. Then we have proof of the ABLE account. We have proof of the exact dollar that left this account went to the ABLE account. That's totally legit. But if you just take the money out and think that they're not going to ask about it, that's where it's not legit, and they will definitely ask. Okay.
And
so
just,
once
I was going to say, just one thing, anytime anytime there's a change with Medicaid or Social Security, you have 10 days to report that change. So this is such a great question. When you file for guardianship, what happens when you die? Would we appoint somebody else to be guardian? Couple of things. Only parents or married couples can be co-guardians of somebody. There is a gap in the Texas law or the Texas estate code on what happens when a parent dies. It's a tough decision. You can appoint somebody in your documents, but they still have to go through the vetting process. They have to go through a criminal background check. They have to go through a new hearing. I have a case right now where the mother is getting older. She's the guardian of her daughter. The daughter's sibling is we are getting ready to appoint her so that they're doing that transition of the guardianship during the mother's lifetime, so there is no gap period. So that is a concern. Okay, our next slide is updating beneficiary designations. The one thing I want to pull off this sheet is a little secret is I have an Excel spreadsheet where I track all of my beneficiary designations to make sure they're perfect. Because if there's a beneficiary designation that gets paid out directly, as we've talked about, it can cause big problems. I always, and like Allison said so beautifully, we always want to get confirmation back of that change of beneficiary. Okay.
And I will have to tell you, I do this for a living, and I had a whole bunch because I had updated all of our documents at the beginning of this year, and I had a whole bunch of change of beneficiaries. And do you know, I would say that I think we had to resubmit them, like over half of them twice because they were wrong. It wasn't that we submitted them wrong, they inputted them wrong. So that confirmation that we came back,
Yes.
it's important to look at
Very
those confirmations is basically what I'm saying. And I do this for a living. So we go back and look at the form and be like, nope, we submitted it right. They just did it wrong. They just took it and messed it up. So very important. Okay, so and everybody is going to get a copy of today's slides and a link to the recording. So let's talk about, we just have a few minutes left. Let's talk about the estate planning decisions.
So the person that's in charge of your kids' money or your loved one's money, I think has to have the 3 T's: time, talent, and trustworthy. If they're missing one of those, they don't need to be appointed in the document. If someone's not good at handling finances, they don't need to be a trustee. We have a lot of questions about, should a sibling be a trustee? My concern is that you take the sibling out of the sibling role and you put them in a money management, which can cause friction. So maybe we think about a corporate fiduciary. We also have questions about how you divide the estate. So I always tell my families, sometimes what is fair is not what's even. This is a situation in my house. My kids are going to share with their cousin. If I die, they're going to have to share some of their estate with their cousin who has a disability. A letter of intent for medical instructions and from instructions to the trustee. That's where you can use your voice after you die or you become incapacitated on how you want the money used. Allison has a great webinar on YouTube on that, so take a look at that. Anybody that you've appointed in any document, please make sure that they know and have said yes. I have lots of family members come to me and they're like, I didn't know I was named as a financial power of attorney. This is not really a role I want to play. So make sure they are aware of that. We've talked about the beneficiary designations and then updating your documents once a year. Make sure that you check everything if you've had a death or divorce or job change, and make sure that everybody named in your document is still willing and able and wants to serve. I've had some family changes in my life. My brother got remarried, so now we have another person to be responsible for our children. So that was a change that I had to make. So it's something you need to do very, very carefully and look. But the key here is getting the right people in the right position. So who's good at medical decisions? They need to be making medical decisions, be the guardian of the person. If you've got a loved one that's an engineer, maybe put them in charge of the money, because they are usually pretty good. Engineers and school teachers are usually good at handling money and being organized. So, and you don't necessarily have to family member. So think outside the box. Think who's in your community, who's in your neighborhood that you are close with, that you trust. And those are the people that you should be thinking about naming in your documents. Okay.
And I would say, I always, and I just want to mention this because sometimes it's hard. A lot of our parents or grandparents keep their cards close to their chest. They don't want to talk about their documents. So I would say, again, have these intentional conversations with the loved ones in your life about their documents. We've seen where, you know, mom or dad died and they had their documents done before, and then they never updated them after the first person's death. And then all these people that were named in the documents as successor, you know, executors, they're all dead. I mean, I had a case a couple of years ago. There was like 9 people named as successor executors, and all but one of them was deceased, and the one that wasn't deceased was 96 years old and didn't have, you know, of course, the wherewithal to handle that kind of estate. So I do think it's important. So one thing that I would say is, you say this, listen, I've been, you know, thinking about and doing some planning for little Johnny. We've been getting our legal documents in order, our wills, our special needs trust. We've learned that there's a right way and a wrong way to leave money for the benefit of Johnny in the future. And we've learned that most advisors don't even know about this. And we wanted to share a little bit of the planning that we've been doing, and, you know, and educate you on the right way and the wrong way to go about doing this. Your parents and grandparents, they want to do the right thing. They just don't know, and their advisor doesn't know. And then you can also take it one step further and say, well, I don't want to get in your business and I don't care about the money or anything like that. What I realized is I don't know what your documents are. Like, for instance, if something happens to you, who's your power of attorney, and, you know, your healthcare power, who's making decisions for you? Be intentional in having those conversations. Don't wait. Please don't wait until that stroke happens and somebody's incapacitated and you're saying, snap, coulda, shoulda, woulda, we were going to do it. It was on the shelf. We didn't do it. And now now we're having big issues as a result of that. So I know we're out of time. We're 1 minute over. Christina, you did an amazing job, and you always do. This is so
I feel
good.
the same way about you, Allison.
It's so good, and it's a lot of information, guys. If you're ever feeling overwhelmed, that's why we do so many webinars, is to break it down into bite-sized pieces. Like every topic we talk about, whether it's guardianship, our first party or third party special needs trust, or a letter of intent, or an ABLE account, guess what? They have all of their own webinars for the details, so you can go deeper, and they all live on the Consolidated Planning Group YouTube channel. You can check them out. We've got every topic that you can think of out there. There's over 300 webinars out there, so you can peruse the topics. You guys are going to get a copy of today's slides. This link right here will have our upcoming webinars that you can register for and see the titles and see, you know, what we've got coming up. I do know one of the big popular ones is housing, and I believe that we've got a housing one that's coming up in the next couple of weeks. So if that's on your radar, check that out. And on our YouTube channel, we have 3 or 4 other housing webinars. And what we do on those is like a speed dating, I call it, where we invite other organizations that have housing for individuals with a disability, and they get 3 or 4 minutes to tell us who they are, where they're at, who they serve, how much they cost, and whether or not they take waivers, and if they have openings. And it's just designed in the course of an hour for you to be able to pick out a few that you want to go deeper with, maybe go tour, check out their website, or what have you. Guys, we work on a collaborative team here at Consolidated Planning Group. We're always stand ready to help. So does Christina Lesher and her awesome team there. We do initial consultations. So if you need help, you need legal help, you need financial help, reach out to us. We can definitely help you. We want to sit on the same side of the table as you and be a productive member of your team as you go through the planning process. So Linda, thank you. Thank you for having us again today, and we will look forward to partnering again with you soon. Okay, and guys, please don't forget Linda's survey. Don't forget her survey. She needs that survey for their grant.
I have opened the poll, the poll for the survey. Thank you very much, Allison, and thank you, Christina.
Thank you.
If you do need to speak with one of our representatives, you can call us at you know what? I just almost forgot where the 800 number. You can call us at 855-974-1368. You can also go onto our website, which is PRN Texas, Texas is spelled out, .org. And we have lots of information on there. We have tons of fact sheets, and we have trainings and just a lot of information that's good to know. And I think that's it. Pretty much we're done. And I really appreciate you guys for coming on and being here. And we look forward to seeing you again.
Thanks, everyone. Have a great afternoon.
I will leave the poll open for just a few more minutes so that everyone that's working on it can go ahead and get it finished. And thank you much.